Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Oxford University Press, and it's an important area of modern law concerning a subject called covert policing. The book is the law and practice relating to covert policing, and it's a second edition which has been written by Simon McKay. Now, my wife Elizabeth and I have looked at the book and discussed it, and we've given it a title for our review of Covert Policing, the Legalities and Illegalities of Our Emerging Surveillance Society, revealed in this new edition. And we'll explain what that means in a minute. Let me show you the book first. Here it is. There's the front, the spine and the back. There's nothing on the back. The book's a hardback and it runs to something approaching 400 pages. There is the index, which is at the back, and you've got a standard structure with paragraph numbering on the sides, which we're all used to in the legal profession, and footnoting, a lot of detailed footnoting. If we go to the front of the book, you can see the main front page there. Then you've got an interesting quote, which is worth looking at. You can see it there. And if you understand that, you're probably a better person than many of us. Then there's a preface, which is well worth reading, which sets out the basic position concerning the book. Then the content section itself, the various chapter headings, there are 11 in total. And then there are conclusions at the end, which is quite useful. Table of cases, some very interesting cases which my colleagues have done in this area of law. You can see them running through the case law. Then there's a lot of legislation, of course, as well. And then after that you've got the European directives and various codes and guidance, which again very important. This is the acquisition and disclosure of communications data, code of practice. Table of international instruments. Then again, a very useful list of abbreviations, because whenever you deal with intelligence matters in particular, you do have a lot of abbreviations. I mean, we know what some of the basic ones are, but it's always useful to have that in case you don't quite know what something stands for. Now, at the beginning of the book, you see the chapter. We've got a short index at the beginning of each chapter and each part, which makes it a lot easier to find things quite quickly. And it starts off, of course, with an introduction to covert policing, the law and practice, exploring and applying methodology of approach. And what the actual author says at the beginning is there can be little doubt that covert policing law in the United Kingdom is entering a new epoch. And that's exactly where we are at the moment with the book. If you look in the middle of the book, you can see how detailed the information is, and then right at the end, as I indicated before, you do have some very useful conclusions about where we might be going with this particular controversial area. Now let me explain in a little bit more detail what we think of the book. Well, this is what we say. The title of the book refers to covert, in other words, undercover policing, which inevitably encompasses the activities of the intelligence services. Mainly that would be MI5 or 5 and GCHQ, based in Cheltenham. The subject matter, of course, is the legal framework in which these activities may be carried out. The resulting legal landscape, with its inbuilt tensions, controversies and conundrums, is nothing if not complex, as revealed in this book, now in a second edition from Oxford University Press and admirably written by Simon McKay. Speaking of controversies, the book contains much discussion of and a detailed examination of RIPA, the Regulation of Investigatory Powers Act 2000, the Reg and Veg Act, as it was known to a certain extent. It's a controversial piece of legislation, anticipatory in its day, and in the words of some practitioners, a disgrace. And I'm well aware of the views of many people concerning the powers that were contained in that particular piece of legislation, which, as I've indicated, is and remains controversial. RIPA has certainly engendered some strong opinions, often unfavourable, including the criticism that under the Act, powers of surveillance given to the state are too substantial. And via references to cases and case law throughout, accompanied by incisive commentary, the book explains what these powers are and, for the most part, views with alarm the emergence of what might become, or has already become, the surveillance society. Discussed and examined both extensively and in illuminating detail are issues of privacy, security, freedom of speech, and human rights-based arguments. So all the main issues are looked at in the book. And as the author, Simon McKay, reminds us, quote, "Undercover police operations give rise to both practical, jurisprudential and philosophical questions, all of which, of course, should be more than a little concerning, not just for lawyers and academics, but for the public at large." And how many, for instance, are not concerned by the newly acquired state powers to eavesdrop on every email transmitted, allegedly, or website visited, allegedly. Now, the problem really is about how far we go, and the book, I think, gives you a balance as to where we are at the moment, whether you actually agree with the way in which covert policing operates or not. I think the important thing for the bar in particular, because we deal with quite a lot of these high value cases and difficult hard cases in the criminal jurisdiction, I think that the importance there is for us to get some idea of exactly what is going on, because we will be privy to some information. And again, the question really is about secrecy, confidentiality, and what must be in the public interest if justice is manifestly being seen to be done instead of being conducted, say, behind closed doors. So there we have it. Obviously, in McKay's opinion, the state has gone too far. He quotes the fairly recent statement from the Foreign Secretary that if you're a citizen in the United Kingdom and you're not doing anything wrong, then you have nothing to fear. That, of course, is the standard point any police officer would put to you. However, we have had instances of abuse and instances of downright illegal behaviour in the past, which, of course, the bar and the judiciary try to redress as in terms of balance. But we do have these problems from time to time. It's no good sort of looking away and thinking that they'll go away. The point is we have to monitor what's going on. We have to have that review system. Obviously, judicial review is for much wider general public sector decision making. But we are looking here very much at what the police get up to. There's another quote which McKay adds. He says, "It is difficult to avoid the resonance that this has with the great writers of the past." And this is the sort of problems we're talking about concerning "We Got Nothing to Fear." And he refers with alarm, of course, to the chillingly prophetic works of Kafka, Orwell and Conrad. And if you've read them, you'll know exactly what we are referring to here. One might say that the book reveals the time-honoured tug of war between what the state wants kept secret and what defence lawyers, not to mention investigative journalists, for example, want to ferret out. And as I said before, that's where the balance is. And the difficulty in any free society is maintaining that balance. That's why we have the greatest bar in the world in this country and a very good police force, notwithstanding some bad apples. So anyone doing any further research within this area of law, which has certainly become highly topical, will appreciate the extensive tables contained in the book of United Kingdom legislation, statutory instruments, European directives, international instruments, because there is this international global concept, and codes and guidance. Paragraphs are numbered throughout, which I've indicated when you saw the book, and it makes much easier navigation. And there's, of course, a very useful detailed index at the back. Let me conclude by saying that if you are a practitioner embroiled in a case or cases in which covert policing is a key issue, or even a peripheral one, this is an important work of reference which you really do need to acquire. And I think most people would find this an interesting book on a wider readership level as well, because there are substantial jurisprudential issues of modern covert policing which we need to address. It'll be the subject, of course, of lots of exam questions for anyone doing examinations, so do bear that in mind. And the date of the publication is cited at 2015. Let me show you again. Second edition from Simon McKay. There we go. And you can see, just opening it, just right in the middle, applications for authorization requirements. This is on surveillance. And it's fascinating because one of the interesting things I've found as an ex-member of the Intelligence Corps is to try to understand where we have moved in terms of the information that's now available on what people get up to. Because in the past, everything that I certainly was involved in was of a confidential nature, and a lot of that has become open to the public. There is the index itself, which you can see, and it is in fact very detailed. I think for everybody, for instance, interested in this, it is actually about disclosure, and you've got a very useful chapter here on the acquisition and disclosure of communications data. And I think that is going to be one of the big issues that we face in the next half of this decade of the 21st century, because clearly there are very strong views about how far the state can go. Let me just remind you to read the preface, which is there again. That actually sets the scene very nicely as to what the book is about. I found it a fascinating book. It's a subject area that I think a lot of people have very little knowledge of. So I think this adds to the overall legal debate. But as I've indicated earlier, there are jurisprudential issues, there are obviously political issues as well to a certain extent, but I think the balance has been achieved. And in fact, the points that are made are good words of warning about how far we're going to go with this in the future. Thank you anyway to OUP for leading the way with this, and to Simon McKay and all the people involved. It's a very good book. Thank you. Bye-bye.